well, let's kick this off. So, hi everybody. My name is Kwabna Ansa, and I'm the head of communities and strategy here at the LOTE Agency. I'm a qualified IAP2 participation specialist and have worked with cultural and linguistically diverse communities across Australia since 2008. Before we begin, I would like to acknowledge the traditional owners. So I acknowledge that I'm hosting this online meeting on the lands of the Eora, the traditional custodians of the Gadigal. I also acknowledge the traditional custodians of the various lands on which all you meet today. And if there are any Aboriginal or Torres Strait Islander people participating in the meeting, we pay respect to those elders, both past and present. Joining me today is Sonia Vikovic. She's the State Director and General Manager of Settlement Services International. Sonia, pleasure to have you.
Thank you. Likewise, nice to be here with you all today as well. And I would also like to start by acknowledging the traditional owners of the lands. And I'm calling in and dialing in from the lands of the Wurundjeri people of the Kulin Nation. Ancestors, custodian, I pay respects to elders past, present and future, and the continuation of cultural, spiritual and educational practices of Aboriginal and Torres Strait Islander peoples. Ancestors have walked this country, and I acknowledge their special and unique place in our nation's historical, cultural and linguistic identity. I also acknowledge any Aboriginal or Torres Strait Islander colleagues in attendance with us here today. And as has been stated, my name is Sonia Vikovic and I'm the State Director for Settlement Services International, and I also hold the portfolio of General Manager, Clients, Partnerships and Business Growth. And just a real brief, SSI is a social business not-for-profit organisation that works with newly arrived migrants, refugees and asylum seekers and other vulnerable Australians. Our intention is very much around working with individuals to support them in reaching their and empowering them to reach their full potential, whatever that full potential may be. And we do that through multiple areas or attempt to do it through our service delivery, advocacy and influence pieces. So that's a bit about the organisation and a bit about me. I have worked in the sort of not-for-profit sector for 25 plus years, and from small ethno-specific to international organisations, and now in Settlement Services International. So thank you.
Thank you so much, Sonia. So thanks everyone for joining us for this webinar, Do I Need a Will in Australia? So at LOTE, we understand that many families in Australia don't understand the importance of having a will. And even if they do, sometimes they don't have the tools to build one. That is why the LOTE Agency, in partnership with Settlement Services International and with Indian professionals in Australia, decided to conduct this online event to create awareness of this important issue. To give the presentation, we have Richard Mitry. He is a partner at Mitry Lawyers and was one of the founders of the firm in 2009. Richard sits on the board of the Australian arm of the international non-government organisation accredited with the United Nations. And Richard is also a legal media commentator on Australian television news outlets. Thanks so much for participating, Richard. We sure are looking forward to your insights to help our broader community. So before we hand it over to Richard, just wanted to touch on LOTE. So the LOTE Agency is a multicultural research and communication agency, and we provide community insights and communications to help our clients engage with diverse audiences. We have, in our organisation, we have about 27 different languages, and which is ever increasing, which is so fantastic. And for us, we want to share our insights with the world, and that's the reason why we have webinars like this. So before I hand it over to Richard, again, I would like to thank everyone for joining us and listening to this important webinar. Thanks, Richard.
Thank you, Kwabena, and thank you everybody for being on today. I hope that it's beneficial for you. Now, just to briefly touch on what Kwabena just said, I am a lawyer. I draft a lot of wills in my role as a lawyer. I also act in a lot of will disputes. And what I mean by that is when people's wills, for some reason, or lack of wills for some reason, end up in court with families fighting each other. So drawing on that experience today, I'm hoping to touch on a few things with you that I hope will reinforce why I think it's important to have a will in Australia, and also the sorts of things you should think about when you make a will in Australia. Now, what I might do just very briefly is share this screen. This is just a bit of a slideshow. I'm hoping that everybody can see that now. Now, before I touch on anything at all, I'm a lawyer, so I think I wouldn't be doing my job properly unless I had a disclaimer, a legal disclaimer at the beginning of this discussion. What I'm giving today is not legal advice that's tailored to anybody's circumstances. So we have 32 participants here today. I don't know anybody who is on this call. I don't know your individual life circumstances. So for that reason, I'm unable to give any specific legal advice. What I will do is give some general guidance on the law, go through some very general matters relating to the law of wills in Australia. And I would strongly suggest, and I think we might touch on this a little bit later, to please see your own lawyer, your own local lawyer, for legal advice when drafting a will, or any questions you might have about wills, or challenges to wills generally. Now, the first thing, this Scrabble word on the screen, intestate. I want to talk about what intestacy is, or what intestate means, and why I think for this reason it's important that you have a will in Australia. So this is a law that applies around Australia and in many other parts of the world, where somebody dies without a will at all, not with an invalid will, but with no will at all. Now, if you die without a will, you can't assume that you intend what you want to happen when you pass away with your estate, or even in relation to looking after your children, if you have children who are under 18, will be given effect. Now, what I mean by that is that you can't think, because, for example, you wrote an email to your lawyer, or you wrote something down on a piece of paper and didn't sign it, or wrote something on a serviette at the dinner table about what you want to happen, that's what's going to happen, because it very well might be found after you pass away that you had no will at all. Or, of course, if you didn't write a will or anything else down, then it will be the case that you had no will when you passed away. Now, the law of intestacy, or intestate, is a law that's written into the laws of the different states of Australia, which says what will happen with your assets in the event that you do die without a will. Now, what I want to do very briefly is touch on, in broad terms, what the law, and very broad terms, what the law says about that. Now, this does vary a little bit from state to state, but I'll explain the more general rules. So, firstly, if you're married or in a spousal de facto relationship, and you do or don't have children from that relationship only, then your spouse will receive not children, but your spouse, so your husband or wife or de facto partner, will receive your whole estate if you die without a will. It gets more complicated though, because if you are married or have a de facto partner and you have children from a previous relationship, married or not, then there'll be a split of your estate. So everything won't just go to your spouse or any children even from your current relationship. Any children from your past relationship would also receive money, and a little bit less as well, and money and assets, a little bit less than your current spouse. But if you die without a spouse at all, and you have children, your children will receive everything. If you have no children and no spouse, then your parents will receive everything. If you have no children, no spouse, and no parents, your siblings will receive everything. Or if everybody that I've just mentioned has passed away before you, then your grandparents will receive everything. Or if they've also passed away, your aunts and uncles will receive everything. If everyone, including your aunts and uncles, has passed away, your first cousins will. And then if everyone, so if you've passed away and you have no cousins, no aunts and uncles, no grandparents, no siblings, no parents, the state that you live in will receive everything. Now, I'm sure that unless somebody feels particularly generous about paying tax, they probably don't want to give the state their entire estate. Everything they've worked hard to build and own at your passing. Now, it's very unlikely, of course, given what I've just said, that that would happen, but it's possible, and it has happened. But I think I'm hoping by explaining that the way I just did, you'll understand that it is very complicated, right? And it's very unlikely that people actually want that to be the way their assets, the property you own when you die, is given away. And therefore, I think it's really important that the only way that you're going to make sure none of that does happen is by making a valid will. And when I say valid, I mean a valid will under Australian law, or that is validly recognised under Australian law. Now, what I just want to briefly touch on is the essential tools, the essential requirements of a will in Australia. Now, what I mean by this is the formal requirements. So the things you have to have in a will to make sure that the will is actually valid when you pass away. So the first is that the will needs to be in writing. Now that might sound silly, I suppose, because most people would think, well, what's a will if it's not in writing? But you'd be amazed, right? People might leave a voice message on WhatsApp to their spouse about what they want to do when they die, because they realize that they may not have long left. It happens. There may be a conversation where you say, I'm going to give everything to you when I die. That's not a valid will. It needs to be in writing, and it needs to be signed by the person making the will, so with their signature, written signature, not like DocuSign or e-signature, but a physically signed document. And it has to be with the intention of making the will. So in other words, you actually have to sign it knowing that by signing you are making a legally binding document, a document that will bind other people when you pass away. So if you sign something that you think might just be a draft, or you sign it not even realizing, for example, that it's your will, which can happen because people have been tricked, and I'll come to that, then it won't be a valid will. And finally, the will needs to be signed on every page, but not only that, two different witnesses, and preferably not people who are mentioned in the will, like people who will receive your estate. There can be, but preferably not. Two other people need to sign next to your signature on every single page of the will. So if those things are not there, those four requirements are not all satisfied, then your will won't be a binding will. It won't be a valid will under Australian law. It can be fixed, but it often is very expensive to do that after you pass away, for your estate to do that. Now, what I then now briefly want to touch on is the different roles that are in a will. So there are different people play different roles. They have different obligations when a will is made. And the reason I want to take you through this briefly is not because to allow you to understand what makes a valid will, but if you are going to make a will, it's important that you have some broad understanding of what these things are, because most people don't. Most people don't make a will every day, or read about wills, or even lawyers advise on wills every day. So it's when you have a broad understanding of this, it might give you some thought about the sorts of things you'd be armed with if you went to go and see your own lawyer. So the first is the role of the executor or the trustee of the will. Now, what that person or people's role is to make sure that the will, as it's written, is actually carried out. So in other words, that what you've written down in your valid will, hopefully, is actually given effect. They're the ones who generally need to go to the court and get an order from the court to say this will is valid and it now needs to be dealt with. They're the ones who may have to sell property or transfer property if that's what your will requires, or give money to different people, or pay off loans because most people will probably pass away with some sort of debt that needs to be paid off by their estate. That is the role of the executor to make sure that happens. The second is the second thing there are beneficiaries. Now, beneficiaries are people who benefit from your will, using the name of the word. They are the ones who will generally receive something from your will. So it might be your children or your family or whatever. That's known as a beneficiary. The third point there, guardian, it's very important. Most people don't realize, actually, they might say, I just want to give everything to my friend. But when they pass away, they might have children under the age of 18. Now, if you're say you're in an unfortunate situation where that a child under 18 or children under 18 have both of their parents or guardians having passed away, or they only had one parent or guardian and that person has passed away, you can in your will say who you want to look after your children or child if that happens, because obviously somebody under 18 is not, they're not capable of, for example, signing a lease or entering a contract or generally looking after themselves. They need a guardian or a guardian figure or a parental figure to look after them. Now, you can do that in your will. It wouldn't be binding, for example, whereas if you were married to somebody and you tried to appoint somebody else as a guardian, when in fact it should be the other parent who might be the valid guardian at that point. But it's more relevant when there's only one parent surviving or around who's able to do that. And if you do go and see a lawyer or get some legal advice, please make sure to think about, if you have young children, who would be that guardian in those circumstances, and probably have a chat to them as well. Because the last thing I'm sure that anybody would want is to realize while they're grieving somebody close to them, they also now have to look after their children as a surprise. I think it's important to have that discussion, not only with the lawyer helping you draft your will, but also with the person you want to nominate. Now, finally, I just want to briefly touch on trusts. And again, this might relate, doesn't have to, but it might relate to young children. Often people who, for example, own a house or have other assets they want to give to their children who are young, or even adult children who are young, like in their 20s, they might want to give them assets, but be worried about the fact that those children might sell those assets very quickly and take the money and waste the money. Except called a testamentary trust, which can be set up, which basically allows until a certain age, it can be until a certain age of that child, it could be in their 30s or 40s even, for those assets to be stuck, to be held by somebody else as the trustee for that child, so that in other words, they can't go and just sell the assets. Everything is managed by that trustee. There are benefits, and if it's something that you have any concerns about when drafting a will, I'd very, very strongly recommend you speak to a lawyer about that, but also an accountant about that, because there can be some tax benefits for your children if they inherit, or whoever is to inherit assets. There can be some benefits in having a trust from a tax and a law perspective. Now, next I want to touch on some traps. So I mentioned earlier that I get involved in a lot of disputes in cases. So the next couple of, to wrap up this first part of the discussion, I want to talk about some various traps and challenges to wills. So the first is, and probably the one I see actually the most often, is that people will make a will, but forget about certain assets and liabilities. Now that you can say, for example, I give everything I own to my wife, right? Or my husband or my de facto partner, but not realize, and in doing that, you might think, for example, you're giving away shares in a company that you own, that you're a business partner of, for example. Or you might think as part of that, you're giving away your superannuation to that person. Now those two things, as an example, might not be able to be dealt with in your will in that way. There might be other contracts that you made during your life, for example, that mean that you can't actually do anything with those assets. You can't give them to anybody. Or you might own a home or a property jointly with somebody, where they automatically receive that if you die, so you can't leave it to somebody else. So that's, people often make that mistake. They don't actually discuss or consider, maybe because they're not asked the right questions, or if they're asked the right questions, they probably don't understand it, that you can actually miss or accidentally forget to deal with assets as how they have to be. Superannuation is a perfect example. You can't actually leave your super in your will. You have to have a separate document under the income tax law, which is called a death benefit nomination form. So it's important, if you have superannuation, either with a fund like an institutional fund, or even your own self-managed super, you have to deal with that separately. And again, your lawyer or accountant can prepare those forms for you if you haven't already, because you might have without realizing it too. The next trap I want to talk about is will kits. Most people will ask me, when they ask me to draft their will, why should I use you or any lawyer and not just go to the news agency and pay $15 and fill out a will kit? My answer to that is, if you want to do that, do that. I'm not going to give you any advice on that, but that's something you can do. My only concern is that if you have a will kit, it's like going and making a contract, any other contract, because a will is a legal document. It's like a legal contract without legal advice. Wills are actually, I'm hoping, as you probably already realized, they can be very, very technical documents. They have a lot of traps, and I'll touch on a few more in a minute. And if they're not made properly with specialized advice, you may not actually give, it may not give effect to what you want. You might think it does, but only it's after you pass away, people realize that there could have been issues that may needed to have been dealt with. And that's why getting a proper plan done through a will with advice is, in my view, as you know, I'm biased because I'm a lawyer, but I think it's a much wiser move. It's a very important move to take some advice on documents. Now, another is, and this is related to the will kit concern, is formal defects. So I mentioned before that you need to sign the will. On every page you need 2 witnesses. People often, that you may have a lawyer prepare a will, but you take it away and sign it yourself and forget to do that. The will won't be valid if that's done. So it's important to make sure that even if a lawyer prepares a will, please make sure they check it once it's signed, or you sign it with them, just to ensure there are no issues there. Now, finally, in terms of technical traps, I want to talk about capacity to make a will. It's important, and this it can impact people at all ages, but I see this a lot with elderly members of our community. People will make a will often because they're very worried about, they may be quite sick or towards the later years of their life, but they're not able to, for example, remember facts or have rational understanding about their financial position anymore, or understand even the legal consequences of making a will. Now, there have been a lot of legal cases in a lot of courts all over Australia where people have made wills, and then their family has said, no, that person was unable to make a will. They weren't able to remember. They might have had severe dementia, for example, and made a will. That's often something that comes up in courts. Now that would mean that person did not have capacity to make a will. So it's important. And another reason I suggest seeing a lawyer is because lawyers are trained to make sure that they check to ensure that anyone who makes a will is able to properly understand what they're doing at the time. Because again, the last thing you want is to make a will and then have people fighting about that after you pass away. Now, finally, for this first part of the session, I just want to talk about challenges to wills. Now, that judge there is not a real judge, as far as I know. I think it's probably like Judge Judy or someone who looks like Judge Judy. But the last thing you'd want your children, I'm sure, or estate or family to see is a judge's hammer fighting over your will. Now, unfortunately, it happens a lot. It happens more often than you'd like to know, I'm sure, but it happens. And by properly drafting a will and taking careful advice from a lawyer and also from an accountant, and properly consulting with your family, I think often helps. You can avoid some of these potential challenges. So the first thing I want to talk about is what's their rectification. So I mentioned some potential defects before, like people accidentally making mistakes in a will, missing assets, forgetting to name. I've seen wills. I had a case a couple of years ago where someone made a will but had no executor, so had nobody to actually manage the will. What can happen there is your estate, so if it's your family or whoever it is, can approach the court. It would be the Supreme Court, which is the highest court in every state and territory in Australia. And they can ask the court to fix the will. It's called rectification. The problem with that is not only does it take a lot of time, but it's also very expensive. Tens of thousands of dollars potentially to do that. And if it's not done, you may not be able to actually use the will. The next is the lack of capacity, the next challenge. So as I mentioned earlier, not having the mental capacity to understand you're making a will is a basis, and often wills are torn up because somebody didn't have capacity. I'll give you an example, and this is a very real example, and it happens a lot. I had a case several years ago where somebody made a will, an elderly gentleman made a will where he left everything to, he had no family. Actually, he was in a very similar scenario to what I mentioned before at the beginning. He literally had no family at all in the world. He was the last surviving person. He had no children, and that was it. So he left everything to his friend. He then went into a nursing home and had dementia, very severe dementia. That nursing home gave him a new will. And that new will, he was an Italian immigrant. He'd come from Italy for a long time ago, but didn't speak much English. But that new will left everything not to his friend, but to the nursing home. So the nursing home, and yeah, when I'm saying everything, I mean this man had bought property in the 1940s in Australia, and it was worth millions and millions of dollars. And he left it to that nursing home in that second will. Now, his friend, who was in the first will, challenged the second will. They took them to court and said, no, he didn't know what he was doing. He didn't know he didn't understand the will that he was making the second time. And she won. His friend actually won the case and received it because he was found that he didn't have the ability to understand what he was signing. So that's an example. Another is undue influence. Now, undue influence is people may have their children, for example, it's rare, but it happens, putting pressure on them to leave a will, to make a new will, a lot of pressure, so that the person is not acting freely, to make a new will, to leave everything to one child, for example. Wills can be set aside on that basis. Fraud is another one. Wills, sadly, people can forge wills and have forged wills. Not only does that land that person in jail sometimes, but also, of course, the will is not valid. And finally, and the last thing I want to touch on before we move to questions, is family provision. Now, family provision is not necessarily a challenge to the will to try and tear the will up. It's a bit different. Family provision is saying, I'm a member of this person's family, or I fall within the person who passed away. I'm eligible because I'm either a family member or related in some way. And I didn't receive enough in the will to survive, to live based on my own needs. Now, courts have the power to give those people more money from the estate than they received. So, for example, if somebody had 3 children and left everything to 2 of the children, you might see the 3rd child sue the estate to go to court and then receive more money. And that's something that's quite common. And if you do find yourself in that scenario, if you have 12 months to bring an application like that, you should absolutely go and seek some legal advice if you are worried about that. Now, that's all I wanted to touch on today for the first part of this discussion. I think now we're moving over to some questions.
Terrific. Thank you for that, Richard. That was great overview and really called out some critical areas that we all need to be aware of. We were having a couple of us were having a side comment in the comments section where we've called out ourselves that we need to really progress and establish wills for ourselves as well. So the first, I might kick off with the questions, and I noticed that there is potentially a couple in the Q&A, but when's a good time to prepare a will?
I think any time is a good time to prepare a will, Sonia. So it's often people will find if they have children or their first child or more children, that's a good time to draft a will because you have then responsibilities to the next generation. If you buy an asset, like buy your home, for example, that might be a good time to make a will. But really, I think there's no good time. I think any adult should be thinking about making a will sooner rather than later in their lives. I hate to say it, but most people don't until they're very old and often run into those capacity issues I was mentioning.
Terrific.
Do you want me to jump in, Sonia?
Yeah, go for it.
Look, Richard, we had a question from someone on the Q&A, and they basically asked, so if we get a will done from a lawyer, what then is it deemed that you were in proper capacity to make the will correct, and you don't need to attach a medical certificate from a doctor with the will?
That's a really good question. No, it's not deemed. In fact, most wills that are challenged for capacity have lawyers involved. So the problem is the lawyer is accused of not checking that person's capacity properly. So there's no assumption that just because you see a lawyer you have mental capacity. The lawyer still has an obligation to make inquiries to make sure that you do have capacity if they're suspicious about that. And specifically, what I would often do is actually get that medical certificate. I'd ask that person to see their doctor and obtain a certificate which says you have the ability to make a will, you have that mental capacity to do so.
Yeah, that's great. Sonia?
Yeah, okay, so the next question is the public trust okay to use to make a will?
I think, so what I understand that to mean is the public trustee.
Yeah.
The public trustee is a government body. It's in different states, it has a different name. In New South Wales, for example, it's called the New South Wales Guardian and Trustee. But the idea is that it's a state body which can provide services like executor services. And yes, it is okay to do that. It happens a lot. Again, it depends on everyone's individual circumstances. You might decide based on your own family circumstances that you want an independent government body to be your executor and trustee. But it's not, there's certainly, I wouldn't criticize it in any way. It just depends on everyone's circumstances.
Thanks, Richard. Another question that we had from, and everyone attending, please provide more questions. These are really good. What is the average fee for a lawyer in Australia to make a will? Now, I know that's quite broad, like how long's a piece of string, but yeah, that's one of the questions, Richard. What would you say on average?
Do you mind repeating that? Just
what is the average fee for a lawyer in Australia to make wills?
That's a good question. I wouldn't say there is an average fee. And the reason I say that is everyone's circumstances are different, and wills can be very simple, in which case the fee would be much lower, of course, or they can be very complicated. I've been asked to draft wills that can be 50 pages long, right? And I'm involved in a case now in Victoria, for example, where the will was about 50 pages wrong and there were about 50 pages of mistakes in the will. So, so the short answer is there is no general fee, but what I would advise anyone making a will is make sure you get a written fixed fee or estimate of fees upfront before you do anything, before you engage the lawyer, so you know how much it's going to cost you. The last thing you want is to get a big surprise of a big fee that you weren't expecting.
Yeah, excellent advice.
Terrific. Okay, the next question is, when one dies without a will, can relatives living overseas lay claim to the assets?
Yes, short answer is yes. It's a bit more complicated, but I'm assuming that question means Australian assets, because it's under foreign assets, they're subject to different laws in different countries, but yes, there's that's possible.
I just want to pick up on that, Richard, because a lot of cold communities do have family abroad. So, how does that work, especially if they are a refugee and they're here alone and something does happen? What are some of the kind of navigations? I mean, just give us a high level aspect about that. Yeah.
No, that's a great question. Well, firstly, you can leave assets to foreign people who don't live in Australia. So if you have assets in Australia that you want to leave to someone who's overseas, you can do that. You can. There may be some tricky legal issues about putting, for example, a property in their name, because if it's an investment property, it needs approval of the Australian Foreign Investment Review Board, which is a government body that has to approve foreign ownership of assets. So that's one, that can be tricky, but so that's another, if a person is living overseas and they're left out of a will, to pick up on that last question, then they can challenge the will just because they're overseas. It is harder, obviously, because you're somebody who's living in a different country trying to deal with something in an Australian court, but it's possible. The one thing that's important to understand, and I touched on this, is that if you have assets in your home country, wherever that is, often people do, they leave either as a refugee or otherwise and go to a different country like Australia, but you leave assets in your home country, I would strongly recommend that you make a will in that country as well. So you can have an Australian will, but it's not absolutely necessary but it's actually a lot trickier and it won't always work if you try and make a will in Australia, for example, and then leave assets in Greece to somebody under your Australian will. There's an international convention, like a law that applies, that binds a lot of countries, not every country, and in fact, not as many countries as you'd hope, that says that different wills can apply, but different laws are in different countries, right? So it's important to make sure that the will that you make in each country for anywhere you own assets deals with those laws and addresses those laws and complies with them.
Fantastic. Another question that we have, and obviously you talked about married couples before, should couples have their own separate wills? Is that something that you advise? From Sabina.
Definitely. Couples can't make a will together. Only one person can make one will. So yes, if couples should separately make wills, I would suggest doing it together in terms of coordinating what you do, because it may, you don't want one person thinking something would happen and another person doing something completely different in a marriage, for example. So often I will deal with a husband and a wife who come to my office, or two partners who come to my office together, and they say, this is what we want in our will. And separately, I will make two separate wills because you have to, but they will coordinate. They'll work together. Is
that a conflict, Richard? So I guess, do they need separate lawyers, or is it?
No, not generally. A conflict would only arise if somebody wants me to hide something from someone else. There are other ways, but and then that other person wants to sign a will, but they're being tricked about something, or that would cause a conflict for a lawyer. But no, everyone's on the same page, then it's okay for one lawyer to make both wills.
Awesome. Sonia.
Yep. So another question we've got is, what if the executor dies before yourself?
Yeah, that's a good question. It's actually a question I ask every single one of my clients who ask me. So whoever that person is should be a lawyer. Whoever asked that question has a good legal mind. Basically, I would always suggest that you have a backup executor, or backup executors, more than one backup executor, for that reason, because obviously it can happen. Nobody knows what's going to happen after you sign your will. And to try and avoid somebody having to, so there are a number of things that can happen. One is that if you don't have that backup and that person dies, or all of the backups die as well, another person can apply to the court to become an executor. That's one way. or the state, the public trustee that was mentioned before, might become the executor in those circumstances.
An interesting question that we've received: where should I keep my will? Because that's a very, we're constantly moving, especially young people, young adults, they're constantly moving. Can they keep it on the cloud, or does it need to be a physical copy, or does it stay with the lawyer? And if so, I mean, every time they access that lawyer, are they paying a fee?
Yeah, good question. You can't put it in the cloud because you need the original. So that's, it's very hard to deal with circumstances where there's no original will. And often and it makes me very sad, but I often get emails that get sent to every lawyer in New South Wales asking if we have the original will from people I've never heard of, because people lose their wills, right? My suggestion always is keep it with a lawyer or in a safe somewhere, somewhere where it will never move, where it will be protected, and make sure you tell your executors where it is. Because if it's with a lawyer, then say it is with this lawyer, and do it in an email. So if that executor forgets, they can look at the email later. It's just the reason is to avoid a situation where you're looking for it. Now, in terms of whether the lawyer will charge you a fee to access it, they shouldn't. I certainly hope not. But if you just want to recall that will from the safe, then generally I don't see that lawyers are charging fees for that. It can happen, but it's not good practice, I would think, to do that. A lawyer will probably charge you a fee to change the will, of course, if that's why you want to access it. But generally, if they're just sending it to someone, they won't. Unless they're posting it, they might charge you a few dollars.
So what you're saying, a digital copy, a will cannot be in a digital copy. It needs to be in a physical copy. Is that what you're saying?
Oh, yes. So when you go to the court to get the order, the probate that I mentioned before, the order allowing the executor to deal with your will, the court makes you provide an original copy. If it's lost, you have to prove. It's a much more difficult process, I'd suggest avoid it if you can, because that executor then has to prove that was your last will and that was an original, and it's not an easy task.
Thank you, Sonia.
Okay, you sort of did answer this one, but I might just get a confirmation. The question is, what happens if you don't have a will? Does this estate go directly to children? Because that's, according to some religions, that is the pathway. But yeah, so if you can elaborate on that, that would be awesome.
Yeah, there's a part of that question that's actually really important, and that's about religions and the way they operate. If you die in Australia without a will, the law that is likely to apply to the way it works is the intestate laws I mentioned earlier, right? So that's now that it would be a lot more difficult to get the mechanics of a religion, the operation of the religion, without your will in place. If you need a religious will, so that obviously there are wills, there's Islamic wills, for example, or Baha'i wills is another one that I often am asked to draft, where there are certain procedures that are generally followed. If you don't have a written will, it's going to be a lot more difficult to make sure that happens. So again, make a will. If that's a concern, please do make that will.
Oh, fantastic. Yeah. We're getting a lot of questions, so keep them coming. Richard, this one's actually quite interesting. So again, if people are not citizens or are in limbo within Australia, creating or I guess, how does that affect them creating a will in Australia? Can anyone truly make a will in Australia, or do you have to be an Australian citizen?
No, you don't have to be an Australian citizen to make an Australian will. In the same way, you could be an Australian citizen and make a will in Greece, right? I'm using that as an example, but because I had to do that recently. But no, you can, if you have anything in Australia that's capable of being left in a will, or even if you don't, you can make an Australian will. So it doesn't matter whether you're a citizen or even a permanent or temporary resident, you can make an Australian will. There may be tax implications, I should say, if you do, in foreign countries, for example. If you have beneficiaries in England who receive part of your estate in England, about 40% of that goes to the English government straight away. So that's the other, but even if you make an Australian will, but yeah, it's you can, doesn't matter who you are, you can make an Australian will.
And just to follow on from there, a will made in Australia, is that recognised globally?
Possibly. So again, it needs to be recognised by that international treaty I mentioned, that international law. I just think it's best to avoid, and I'm sure most lawyers will tell you, it's best to avoid having a situation where you have one will trying to operate in other countries outside. I would always tell a client, if you've got assets in other countries, make a will in that country, because there's no guarantee that it will be recognised in a different country, because that country might not be a party to the treaty that I was talking about. And even if that is a party to the treaty, there might be a technical issue in the will that means it's valid in Australia, but not actually valid in the other country or recognisable in the other country. So I think it's always best to make sure, and if you do have this situation, get your own legal advice based on your own circumstances, but it is always best, in my view, to have a will applying to each country where you have assets or liabilities.
Great. Okay, this next question is quite interesting. Can a person with an enduring power of attorney make a will on behalf of the one who has signed the enduring power of attorney?
Not based on that power of attorney alone, no. That's not generally speaking, you're dealing with assets during somebody's life under a power of attorney. It's that person is not themselves giving that wish, right? It's your will has to be your own wishes under that will.
Fantastic. Keep those questions coming. We've got about 9 minutes left, Richard, and we've just got a few more to get through, and you're doing really well, so thank you. I'm learning so much. Sonia, I know you and I had a discussion behind closed. We're learning so much. We both need to do a will. So, yeah, I will be doing a will soon.
It took me about 35 years to make my will. So.
Cool. All right. Phew. My question from Vinay, how do you make sure, and I think you've touched on it before about having an accountant, but he's wanting to know, how do you make sure that your super is properly distributed to your beneficiaries? And I think that's through the accountant, and my dependent beneficiaries are not residents or citizens or live in Australia. And I guess you've touched on that. So how do you actually really make sure that your super is properly distributed?
Yeah, so it's for that second part of that question, it's best you take advice when you're making this document. But as I mentioned before, there's a document called a death benefit nomination form, a binding death benefit nomination, which is it is the document which needs to be signed to make sure that you're leaving your super to who you want to leave it to. Now, you might say, I leave it to my estate, which means it just goes into your will, to your pool within your will, right? And it's dealt with then under your will. Or you might say, I want to leave this much to my child, this much to my spouse, this much to my grandfather, this much to my best friend, in terms of percentages, right? Because it would generally be a percentage, not a number, because obviously super fluctuates a lot. And then as long as it's binding, and you should try and renew those documents every 3 years to make sure they stay binding. Then when you pass away, that document will go to the trustee of your super fund, the company that manages your super fund. And that super fund should, assuming it's all valid, act on that document and do what that says. But again, please go and see a lawyer about that, because it's very individual and specific.
The next question is a real practical one. What if I change my mind? How easy is it to change my will?
Depends on how much you change your mind. So you might just change your mind on who the executor is, in which case it would be one change. You might decide to change everything in your will because you don't like the people that were in your will before or something. You might just change the way you structured it, right? There can be big changes. Either way, what is important is you don't just go and cross out the will and put the new thing on. That's not valid, right? So that's when you change a will, you have to do one of two things: either make a brand new will, which deletes the old one, because the terms say the old one doesn't, no other will applies, or you can do what's called a codicil. A codicil, spelled C-O-D-I-C-I-L, is a document it varies the existing will. It can be a little bit tricky to do that because then you have to make sure you've got all the documents together. My suggestion is even if it's a small change, hopefully the lawyer who drafted it has it saved on a computer and they can just make those changes quickly and cheaply and fix them up.
Richard, we probably got two more questions here. So the first one, you spoke about married couples before, but this one's quite interesting. What if one couple just doesn't care? And basically one couple wants to make a will and they have joint assets like their family home. How does that work?
What do you mean specifically?
So I think the client, sorry, not the client, the attendees trying to understand, with obviously relationships are hard. We recognize that, and one person wants to create their will, but has a shared asset. Like, so what if they say, I want the family home to go to X person, and the other person doesn't have a will? Like, how does that work?
So if one person has a will and the other one doesn't,
yep,
the one that does have a will, hopefully, if the will's made properly, will have that will carried out if that person dies first. If the other person dies first and they have no will, then the intestate laws will apply. So that, what I mentioned before, it would likely, if that's that person's only spouse and they have no children from a prior marriage or relationship, will receive everything anyway, which means their will would then take everything else that's there into account. If they otherwise just don't care and they don't want to make a will, then again, if no one makes a will, the intestate laws will apply to kick in. It's best to avoid that if you can, because it can cause, it happens, obviously that's why the law exists and it's there as a safety net, I suppose, as a backup. But just know that it may not work out the way you assume it might. Right? Don't automatically assume that your husband or wife or spouse will receive everything. It might be a bit different and can get tricky, especially if people pop up out of the woodwork, because one thing I find is that, I have a case now where there's a love child involved, as in somebody died without a will, and then a third child came out of nowhere from a prior relationship and is now biologically proven to be that person's child. Right, like it was 40 years or something. They hadn't seen them, and no one knew they existed. So that person now receives almost half of the whole estate as a result.
Wow, that's phenomenal. Wow. Sonia.
Okay, final question before we close. Can a beneficiary be the executor, or is this mutually exclusive?
Yeah, that's a good question. Yes, they can. So what I would suggest is, if you're drafting a will and you want the executor and the beneficiary to be the same person, think about two things. One is the backup. What happens if that person's not alive when you die? And secondly, make sure you put a clause in there saying that if you still want them to be, for example, they don't want to be the executor, because people can actually say and ask to be excused as an executor. They can resign or renounce that position. But if you still want them to receive assets or whatever it is, that share, even if they're not the executor, make sure you put that in your will as well. Don't assume that, if they're not linked, the roles aren't linked, then make sure they're expressly separated in your will.
Terrific, thank you. We've got about 3 questions that haven't been answered. I just wonder if we can take them offline and revert back to the group, if that's the best way forward. Is that a possibility?
Yeah, absolutely. We'll collect those and see how we can respond across from that. Thanks, Sonia.
Wonderful. Well, thank you. Thank you, Richard. It was a pleasure having you today. We learnt an awful lot. I think it's actually really highlighted the needs, and there was such interest from the chat that you can see that lots of people have got a lot of questions around the question of wills. It was a pleasure meeting you, pleasure co-hosting with you at LOTE as well. So that's with Kwabena. Really appreciate the invitation and the partnership that we've been able to deliver today. I know that there's a good representation and participation as well. So thank you again. I suppose the takeaway is really go and get a will done. And store it safely and advise people where you've actually stored it and who your executors are as well. So to ensure that if anything does happen, you and your loved ones are covered. So thank you again. It was a pleasure from my behalf. I really enjoyed the session. Over to you, Kwabena.
And thanks so much, Sonia, for joining us. Look, I want to thank Richard from Mitry Lawyers for your expertise. I think really insightful, and especially your link back to cultural and linguistically diverse audience groups, which is really, that's why we're here and do the work that we do across both organisations. So in terms of what's going to happen next, we'll be looking to create a bit of a snapshot of this, a live recording, which will be on LOTE's LinkedIn and YouTube, and which we would encourage everyone here to share with their communities and individuals, because I think this is really knowledgeable information. We'll also be sending out a survey for participants to complete, which we would love to hear your feedback about how this webinar went and whether it was useful. So from us here at LOTE, thank you very much for joining us. And Richard, thanks so much for being a part of what is a great series that we're doing across LOTE. Thank you.
Thank you.